Okay, thank you. Good afternoon. Today is Wednesday, April 1st. We are, as far as I know, not doing any foolish things. Trying not to.
That's awesome.
So this afternoon, we're looking at H559, an act relating to the parole board. We're continuing gathering testimony on that. And today we have Lori Fisher, General Counsel of the Department of Corrections, and I believe you know all of us. So thank you for being here. And we did have a walkthrough, and we heard from the parole board staff, and so we know generally what's in the bill. But if you could let us know DOC's positions and
Sure.
especially if there's any concerns.
Absolutely. Thank you, Madam Chair. Again, Lori Fisher, General Counsel, Department of Corrections. I think it's prudent to explain that despite my position in the Department of Corrections the last 6 months, I was formerly an Assistant Attorney General that was Director of the litigation team that defended the department among 4 other AHS teams. So part of that job also included being counsel to the parole board in a kind of secular manner. And so I spent the last 4.5 years working with Director Ainsworth and the rest of the board insofar as the other side of the table in relation to applications for parole, appeals from those decisions, and violations of parole that the department would bring forth. So my knowledge on this kind of spans both sides of the coin. So I just want to make that clear. The department has no position adverse to the bill. We support the bill, primarily the advocacy that Director Ainsworth has done in relation to the education requirement for the board. As you all know, the statistics from Justice Reinvestment indicate that the number of individuals that are on furlough versus the number that are on parole has kind of switched. And that it used to be more on furlough and less on parole. Now, post Justice Reinvestment, that is flipped course, and there's 700 folks approximately on parole, and in the low 100s on furlough that the department manages. So you can see that the caseload shift over to the parole board then logically would also require that the board members get educated and studied in the criminogenics, the rehabilitative work, the release plan components, and the like. So the department certainly supports the suggestion that they need that support in their to do their work effectively for this population. And I think I certainly have nothing to add or speak to in relation to the appropriations piece on that. And I think everything else that in here that we've been talking about the last few months is supported by the department, and and I think the department's role is part of the training and development in working with Director Ainsworth and the chair of the board is also another welcome. It's already happening to some extent. I think we'd prefer that it happen more, and that would be a positive influence on that relationship as well.
Okay. Other questions?
Yeah, I just, you said that it was a flip between parole and furlough.
Yes, sir.
Has there been any adverse effects, or is just, with people going back into the general population or anything, or has been just kind of in status quo?
We can certainly accumulate specific data for you to answer that question. I would say it closer to status quo than not. The individuals tend to, with the criminogenics, they're going to follow the rules, whether the department engages in that rule setting or the parole board does. There is I will acknowledge there's I call it a wives' tale that you get tighter supervision and closer watch if you're on furlough versus parole. That's not accurate. That's not accurate. Our probation.
Well, at least I know I'm not an old wife.
Step one.
Back to not doing anything crazy. And
Oh, yeah.
me that's walking into that. So I would say no, and I think the probation and parole officers are cross-trained insofar as and I think the direction from the parole board has definitely been more specific on what they're looking for by way of violation or conditions. So there's more use of like graduated sanctions and the like to help people before they would be brought back before the board for a violation hearing. But that's consistent in both furlough and parole.
Can you explain your history and your experience is really relevant to this bill, actually. Can you explain or give us samples of the types of legal matters that the parole board had that you helped with?
Sure.
And just maybe talk about how having a dedicated attorney would be helpful.
Sure. It seems to be something that predated even my tenure in that role, the struggle to provide representation. Let me back up. Historically, what we saw happen was that as we do now, currently, we kind of align things with the Superior Court process that we do in a violation of probation. What would happen is that and this is violation specifically, the parole officer would notify the board that they believe there's a violation, present the evidence and information, and then be available to articulate what they saw or what they are suggesting happened, and allow the parole board to then inquire and talk to the victims and the witnesses and who's ever relevant to the matter. As the complexities of the law and the complexities of the crimes have increased, so has the defense bar and the prisoners' rights attorneys' arguments in relation to the defense of their clients in those matters, which put the probation and parole officers in a position of being prosecutors and lawyers, which they are not trained to do. And the complexities of the issues just gained momentum over time. So that required the Attorney General's office to provide more assistance to the parole board. Specific to your question, the types of matters could be general inquiry on statutory interpretation of something, or Director Ainsworth would reach out and just have a general question about something in that way. They would never be counsel in relation to what the board's going to do with the individual. I just want to make that clear.
Okay.
There was some earlier confusion about that, perhaps in the infancy of this bill. The Attorney General's office doesn't give counsel on what do you do in this situation. And it was more, again, interpretation, training, understanding of the department, and what their policy and procedure was. It might require me to reach out at that point in time to the department and get a subject matter expert to go and explain to the board, well, this is what risk containment means. This is how we handle the violation. So it could be something general like that. And the other thing that I did handle were any appeals that came from the parole board decisions by the individual. Those were, we had a separation on that team of the DOC faction, and then the person, it's usually the director of the team that would counsel the parole board. But as you can probably ascertain, that's a fine line when you have the team that I was managing would be assisting the POs in the prosecution of the violations. At the same time, an appeal comes out of it, and I can't speak to them. I can't look at their materials, and I have to do it completely from the record and for the parole board. And so there are often, and there's part of the statute in relation to the training that requires, if it is specific to a violation and the Attorney General's office is doing the training, the Defender General's team, the prisoners' rights team, is allowed to participate in that training. And that's about as detailed as it is. So as you might imagine, putting a bunch of lawyers in a room to have a training turns into a legal debate in front of the board. And whether the training is effective at that point is questionable. So in general, those were the kind of matters that they would reach out. The frequency of that, I think there was a question on the amount of money allocated and the frequency. They have a very strong director, and I'm not just saying that because she's sitting here. I would say that if she wasn't here. So that's helpful. If they didn't have a strong director who had a grasp on the legal nuances, it'd probably be more of a need for legal counsel. And the appeals for quantity, you can't appeal a parole board decision absent there being a underlying constitutional due process issue. In general, their decisions typically stand. So we would see those due process style arguments maybe 3 to 4 times a year. So maybe once a quarter, we have an appeal out of that. So that's about the quantity of it that they needed. I think the biggest piece is definitely the ongoing training, and as the department changes its process and procedure, I think that's completely relevant to them understanding what conditions they employ with these individuals, and what the impact will be what the understanding will be if there's a violation of those. So, but I think in general, that's a combination of appeals and general inquiries on statutory interpretation. They would sometimes ask me to be at their meetings if they had questions that came up in general. We're seeing this pattern. What does this mean? How does this apply? But that was pretty much the nature of it. But again, I just wanted to be crystal clear. Never was a time that we were asked to or gave any legal advice in relation to the adjudication of the merits of who was in front of them.
Okay, right, because you're the board's attorney. That's okay. That's I find that very helpful. Thank you.
Sure. Really.
So Mary Jane, is there anything you think you should know at this point that is relevant? I mean, is there anything you'd like to add, or it's helpful to have Lori here, and I want to get all of the appropriate information and recommendations that she might have.
Sure. For the record, Mary Jane Ainsworth, Director of the Parole Board. I spoke to a lot of the pieces of the bill yesterday when I was giving the overview of the board. I echo a lot of what General Counsel Fisher stated. This is an initiative we've been working on for a few years, especially around the legal counsel. I'm in full support of this bill. I actually helped write a lot of the portions. It's really looking at modernizing the board, modernizing. A lot of this language is from many years ago, and the population of Vermont has changed. The population, the population of the incarcerated and supervised individuals has changed, and also really giving more. Having the parole board having the option to speak more towards our budget, having our own attorney so we can get that legal advice when we don't feel like we're in a silo, as I said yesterday.
Okay. Thank you. Question, yeah.
Yeah, just to clear.
Sure.
So when you talk about having your own attorney, are you talking about having an attorney actually working for corrections full time? Or are you looking for some kind of contract with a private entity that could then come in and serve when needed?
It would be it would be a contracted attorney. We're looking at the contracted attorney to serve as needed And I believe that's how it's written in the bill, as we would have a contract attorney that would come in and serve as needed. And then I believe that the assistant attorney generals would still be there on top of that to do our appeals in the civil court if they arose.
Yeah, and I'll supplement that may sound confusing considering the kind of the wall that we have on that team. What change that the department has made in the last few months is to ask the attorney generals to not represent the parole officers at the hearing. That creates an adversarial addition to the process that I think is not helpful to the litigants, to the victims, to the board itself. And it also pulls the parole officers out of the business of being lawyers as well. So we've aligned that process with what we do with the judiciary insofar as submitting our affidavit of what we think is transpired, the evidence that supports it, and being there available to make a positive parole recommendation or not, and explain and answer any questions that the board would have as to that violation. So it dialed back, but what that did was shifted the burden back to the parole board to decide what witnesses they wanted, just what questions that we had, and to which dovetails with the training I think that would be required to get them back in the saddle on being able to prosecute their own cases.
Okay, okay. Again, very helpful. Thank you. All right. So I have some just questions generally. I think that's why Scott Moore is here. Perhaps.
Scott Moore, Joint Fiscal, is here to talk about capital bill, but I did send you an email earlier about the parole board numbers,
Yeah.
which I might be able to help answer.
Right. I just noticed that the parole board chair was the compensation was set in, when was this? Oh yeah, 2006. So 20 years ago at $20,500. And I thought it may have increased since then, but it.
Looking at the inflationary factor, Madam Chair, I believe I sent you a note earlier that said accounting for, what the current dollar value of $20,000 from 26 would be today in 2026, it's I think 37,000 is what I think.
Yeah.
So not
Yeah.
quite double,
But in actuality, I believe they're still paid the same rate.
as far as I know.
That is correct.
Right. So I just want to note that and thank them for their service. And I would prefer that we increase that, but I don't think I would get very far.
Isn't that how this is set up? So the 25 plus the 50 to get the 75. That's what I thought we had heard earlier. So there's the clawback of 25. And then 50 is being asked for out of the capital fund, the 75.
Yeah, that's for the legal counsel. No, I'm sorry. I'll be more clear. On page 3, the top of page 30, and this language was not suggested to be changed. It says the chair of the parole board shall be entitled to compensation of $20,500 annually, and that was effective 2006. And 20 years at the same rate is sad or very generous, depending on the way you want to look at it. So that's all it was. And I'm not suggesting that we increase it, but I'm just noting it for the record.
Misinterpret what you were talking.
Yeah. And that was my fault.
Madam Chair, if I may, Chris Roop, one of the fiscal analysts in my office, did write a fiscal note about this bill, and it is posted on our website. I'm happy to send it to you so Ken can post it here if you're interested in looking at it.
That'd be great. And it does include the fact that the compensation is not
20,000. Yeah.
increasing. Yes. All right. So I mean, here's. We'll wait first. Are we good? Okay. Anybody else have anything? So thank you very much for being here. Appreciate it.
Thank you.
And then Scott, you are here.
I'm here because I apologize for being late. I wanted to be here earlier to help support the fiscal notices of this bill. But I've been chasing the Capitol bill around the house all day. So, but I'm here now. I'm happy to give you an update if you're interested.
Sure, of course, yes.
The
Would
house,
you like to sit at the?
I could sit. I'm one step closer. Again, for the record, Scott Ward, Joint Fiscal Office. This morning, House Ways and Means met and discussed the Capitol bill. They passed it out 10-01, I think it was, 11-00, I can't remember off the top of my head, but there was no issues. And then I just now came from House Appropriations, which is why I'm late. Here for this first part of this meeting. And they also passed it out 11-01, I think it was, or 11-00. But
Good.
nonetheless, it overwhelmingly passed out of both chambers, or sorry, both committees. It is scheduled to go to the House floor on Friday. I anticipate they'll get it to the Senate Tuesday and maybe in the committee by Wednesday. So,
Okay,
Cool.
Thank you very much.
small, quick, I want to just,
Any major changes from what you showed us?
no changes at all. We did have a couple of questions they had about some policy. Bits and pieces in the bill, most notably about, the Little River leaks arrangement that's being made. Please, need some questions about how much income that might derive at this point in time. It's too early in the discussion to have any sort of estimate on that. And the House Appropriations had a questions regarding the DCF Youth Stabilization Facility, what's going on there. So other than that, no changes, just some people having clarifications. If anybody's curious and bored and want to go visit the House floor and listen to them report, you'll hear all about it on Friday morning. You
okay,
might have other things going on too.
we might.
Another 1.25 million in the Scott Moore retirement.
I can either confirm or deny. No, sir. I only get the small pittance for myself. There's no semblance of impropriety over here.
No, no,
None.
none intent, I'm sure.
But yes, so when we get the bill, we're happy to come in and it might be helpful to have Chair Emmons come in and sit down and go through and explain
Yes,
the changes. I know I have the numbers that change, but the wealth of knowledge that she has as to all of the background for all of the whys, it's good to have under her.
yeah, and she has indicated that she'll do that,
It's
which is great.
I think we've done that in the past. I think
Yeah,
last year.
we did it last year, yeah.
Senator Amos, I think we did it when you were chair too. Yep. At least the last 3 years I've been on the chair.
Absolutely.
Yeah,
That's all I had, but I didn't interrupt.
No.
no, you're never an interruption, and we look forward to seeing you more.
I'll be in.
Thank you, Scott.
Okay, thank you. All right, so tomorrow we're going to look at 550, 550. Which is the gender equity bill, and so we'll have a few at this point, at least one confirmed and a couple and three invited from DOC, WellPath, and the individual they spoke of. So if there's any particular person that you'd like to hear from, let us know.
Okay.
And then we have H-294 Friday. And then we'll get the staff back because the house will be finished. So we can, we'll have access to our people, which will be good. All right.
All right.
Okay, we are adjourned.